Thank you, Professor Keat. There are probably worse stories to tell about me, but those are some of the best. Let me begin. Members of the faculty, colleagues, and students, it is a great privilege for me to be here at the University of Saskatchewan to deliver the Halyk Advocacy lecture. Today, I'm going to talk about the changing context in which test case litigation occurs and address some of the barriers as well as the opportunities for this litigation. I don't need to say anything more about Halyk. He's well known as an advocate. Indeed, we all owe a great debt to his competence, not only as a criminal defense lawyer, but by God, he was a civil litigator. And for those of us who practice at the criminal bar, the one thing we learn is don't cross the line easily unless someone is holding your hand. Now, this lecture really celebrates and challenges those in the law school and those in the early stages of their practice who will become the leaders of the bar in the 21st century and who are charged with this responsibility. You will be obliged to promote and uphold the rule of law. You will continue your work further refining the constitutional principles housed in the Charter of Rights and Freedoms. And perhaps most importantly, you are charged with the responsibility of holding the state to account when state action infringes the fundamental rights of those in the Canadian community. And these obligations, if you discharge them, will make you worthy of being trustees of the values that make justice tangible, make it real in our communities. Justice is not the correct technical application of rules of procedure and the rule of law. Justice is about working towards creating an inclusive society dedicated to tolerance and equality and the right of every person to share and participate in the benefits of our community. I have said on other occasions, and I will repeat it, that this trusteeship requires that you do not bend to fear or those who pander to it. In Suresh, a very important Supreme Court of Canada case dealing with a man who faced deportation as a refugee to a country where he risked torture, the court unanimously acknowledged the need for government to use legal tools to meet the challenge created by terrorists. But the Supreme Court of Canada had this caution. I quote, "On the other hand stands the need to ensure that these legal tools do not undermine values that are fundamental to our democratic society. Liberty, the rule of law, the principles of fundamental justice, values that lie at the heart of the Canadian constitutional order and the international instruments that Canada has signed. In the end, it would be a Pyrrhic victory if terrorism were defeated at the cost of sacrificing our commitment to those values." I am first and foremost a criminal defense lawyer, although in the last decade my areas of practice have evolved to do a lot of national security work. Had I spoken to you 6 or 7 years ago, I probably would have said, somewhat smugly, that Cy and my generation of lawyers practicing criminal law had spent 3 decades vitally engaged in the work of breathing life into the Charter. These were also decades that the administration of criminal justice, pushed by the defense bar, saw a paradigm shift. And I want to talk about that paradigm shift. Because no longer when you go into a criminal law class in a law school today, no longer do courts say, we can paint a picture of the administration of criminal justice. It is so finely tuned, it ensures only the conviction of the guilty. Indeed, when I went to school, this view was captured by statements that reflected decisions of our courts that we had created a system that ensured it was better to let 10 guilty men go free than convict one innocent. Indeed, in those early days, most thought we had gone too far, and such procedures coddled the criminal accused. What was the paradigm shift? It occurred because of the deeply disturbing phenomenon of high-profile wrongful convictions. Marshall, Milgard, Moran, Sofino, Parsons, etc. We grew to understand we cannot presume that the administration of criminal justice does not suffer from very serious failures. Investigative techniques, forensic science or junk science, expert witnesses testifying to matters where there really is no expertise and no empirical evidentiary support for their views. With that recognition, we knew that we could not presume that our system promoted the conviction of only the guilty. New rules, new areas of science, all must be tested and challenged against the standard of protecting the innocent. Now, this realization, this paradigm shift, occurred largely as a result of the work of commissions of inquiry. And you've heard that Cy was involved in one. Those commissions of inquiry set about a critical examination of the administration of criminal justice and asked the question, how could it be that we convicted an innocent person? The commissions of inquiry didn't stop at individual circumstances. They looked at the criminal justice system and they looked at the systemic issues that affected it. The first such inquiry involved Donald Marshall. It was conducted by 3 very senior jurists, one from Quebec, one from Ontario, and one from Newfoundland. Donald Marshall was a 17-year-old Mi'kmaq Indian. He was charged with the murder of Sandy Seal and languished for 11 years in prison for a crime he did not commit. When the commissioner's much-anticipated report arrived in 1989, it turned out to be a scathing indictment of the administration of justice in Nova Scotia. In the opening paragraph of the report, the commissioners concluded, quote, "The criminal justice system failed Donald Marshall Jr. at virtually every turn, from his arrest and wrongful conviction for murder in 1971 up to and even beyond his acquittal in the Court of Appeal in 1983. The tragedy of the failure is compounded by evidence that this miscarriage of justice could and should have been prevented or at least corrected quickly if those involved in the system had carried out their duties in professional and competent manners. That they did not is due in part to the fact that Donald Marshall is a native." One finding stood out. One recommendation stood out. The Crown prosecutor had failed to disclose important exculpatory evidence. What's important, what fed the paradigm shift, was the fact that those conclusions fundamentally began to affect the administration of criminal justice. It took note. 2 years later, the Supreme Court of Canada had occasion to consider the Crown's obligation to disclose in Regina and Stinchcombe. The court concluded that a constitutional duty to disclose all fruits of the investigation that are clearly not irrelevant was present. And today, Stinchcombe remains one of the most important decisions. But in reaching the conclusion, the court relied on the Marshall Inquiry, relied on its recommendations, in particular, the conclusion that anything less than full disclosure falls short of fair play and decency. The discussion between the inquiries and some major charter cases, the lack of confidence that we knew we I mean, the lack of, I don't want to say confidence, that's not fair to the administration of justice. The fact we knew it could go so wrong made many things begin to shift. And let me take a moment to talk to you about a case I feel very passionately about, the decision of the Supreme Court of Canada in Burns and Raffay. In that decision, the court concluded that extradition to the United States without assurances that the death penalty would not be sought or imposed was a violation of Section 7 and could not be justified under the Charter. Whether I'm right or wrong, most of us who were involved in the case and who have read and reread the decision of the court view it as a powerful expression by our highest court that the death penalty is simply not in the cards in Canada, that it would never survive an attempt to reintroduce it. And when the court looked at what the death penalty was really about, the decision opens with some observations. And again, they were informed by the wrongful convictions that we knew had occurred and that were now being exposed in the United States. Unanimous court stated, quote, "Legal systems have to live with the possibility of error. The unique feature of capital punishment is that it puts beyond recall the possibility of correction. In recent years, aided by the advances of forensic sciences, including DNA testing, the courts and governments in this country and elsewhere have come to acknowledge a number of instances of wrongful convictions for murder, despite all the safeguards put in place for the protection of the innocent. The instances in Canada are few, but if capital punishment had been carried out, the result would have been the killing by the state of innocent individuals. The names of Marshall, Milgard, Moran, Sofino, and Parsons signal prudence and caution in murder cases. Other countries have also experienced revelations of wrongful conviction, including states in the United States, where the death penalty is still imposed and carried into execution. So then the court set out to review, what do we know about wrongful convictions in Canada? What do we know about wrongful convictions in the United States? And this was in an era where Governor Ryan of Illinois, who was a proponent of the death penalty, put an end to it, or put a moratorium on it in Illinois, and ultimately 50% of those persons on death row were exonerated. That is a staggering statistic. And so in conclusion, our court held that the recent and continuing disclosure of wrongful convictions for murder in Canada, in the United States, and the United Kingdom provide tragic testimony to the fallibility of our legal system, despite its safeguards for the protection of the innocent. And then they concluded, when fugitives are sought to be tried for murder by a retention state, however similar in other respects to our own legal system, this history weighs powerfully in the balance against extradition without assurances. And those assurances, of course, are required today of foreign states, and they must promise not only not to seek and also not to impose the death penalty. Well, let's fast forward 20 years or so to today. And it seems to me that the landscape is radically changed. From the kind of optimism and expansiveness and inclusiveness of those years, I'm going to suggest that we have arrived at a period of profound retrenchment, where we struggle simply to preserve some of the gains previously won, and sometimes where defense counsel are increasingly painted as frustrating rather than fostering access to justice and the rule of law. It is my view, and I know there will be others who may disagree, that we are confronted by a desperately cynical politics that seeks to inflame and harness public fear and anxiety in the service of a law and order agenda. Where once we looked at our neighbors to the south and congratulated ourselves on our comparatively compassionate, restorative, and rehabilitative approach to crime, we now are determined to import the worst of American excesses. The rhetoric of truth in sentencing and the most serious time for the most serious crime are now familiar to our ears. Mandatory minimum sentences chip away at judicial discretion and the opportunity for second chances. Successful, effective programs like prison farms are closed for reasons that can only be described as punitive. Concerns for civil liberties, the rights of the accused, or humane treatment of prisoners can scarcely be heard above the clamor for safe streets and zero tolerance. While these developments come at a significant cost, it is my view that the greatest cost will be incurred by the securitization of the state. According to our Prime Minister, we are at war. As a result, we have enhanced the powers of the security intelligence agencies like CSIS and CSEC. We will be asked to accept the erosion of our privacy interests in the name of ubiquitous surveillance. We will be asked to accept stripping citizenship from Canadian citizens who happen to have access to another citizenship. Not that they have dual, but who happen to have access. I'm going to take a moment to tell you a little story. Many years ago, I represented a young man by the name of Stéphane Hashemi. His mom, Ziba Kazemi, was a Canadian citizen who happened to be in Tehran taking some photographs outside of Evin prison. She was promptly arrested. She was put into Evin prison. She was interrogated, raped, and murdered. When her death became known, there was a meaningful attempt by Foreign Affairs, and the idea was we would try and go get her body. There would be a group of pathologists who could do a postmortem examination, and perhaps something could be done or said about the treatment she had received. So Stéphane, we had the support from the Canadian Embassy in Tehran. They said, come, and you can try and negotiate with Ziba's mother, and we'll try and get the body, and we'll get it out of Iran. We walked into the Iranian embassy. This young man was born in Canada. This young man had never set foot in Iran. And we asked for visas, and it was like the fly on the wall in some respects, because they smiled at me and they said they would accept my application for a visa, and they looked at Stéphane and they said, oh, you don't need one. We consider you Iranian. And I had that, I don't know whether you're all too young, or most of you are too young, to have seen the movie Missing, but I had that sense. We'd be walking into an airport together, and then all of a sudden someone would say, you go into this line, and you go into this line. So, I mean, the potential harm to Canadian citizens and the consequence of stripping citizenship is enormous. We will see preventative detention. It's just coming around the corner. Detention without charge and without trial. And it will be based on whether the intelligence agencies of this country have determined someone is a security threat. Having done 10 years of litigation in the national security world, I want to tell you that they get it wrong sometimes. We shipped Maher Arar, who I represented, we shipped him to Syria by providing the Americans with wrong information and not objecting that a Canadian citizen was being rendered. He was interrogated. And as he said to me, the worst part of it all was to hear the screams of women. And eventually you'd sign anything. Of course you would. You have no way of knowing whether you'll ever leave alive. There's a minimal hope. But it is a terrifying reality of intelligence. And I don't think we can assume it's going to be any different today. some of it will be correct, and some of it will just be wrong. Now, I suppose that list tells us that we, or you folks down there, because we're almost at the end of our litigation careers, have years ahead of you of work. I came out here having written this, and I thought, you know, maybe Harper was elected as part of a conspiracy of lawyers to provide enough work for at least 30 or 40 years of litigation. Anyway, leaving that aside, I want to talk about one of the big problems with test case litigation. And I am guilty of it, although I'm not sure we ever thought that what we did would cause the problem. And it arises, and I'm going to give you an example. You will probably all be aware of the recent Supreme Court of Canada decision in Canada v. Bedford. It was a classic piece of test case litigation. And when one looks at its aftermath, it tells you something very important about the limits of the judicial power. The court was presented with 88 volumes of expert and experiential evidence. And the court unanimously ruled that the existing criminal laws governing sex work in Canada were causing harm to the safety and well-being of sex workers. I appeared on the cross appeal, which was largely arguing about the prohibition around communication for street sex workers. And the Court of Appeal had rejected that argument in terms of whether it violated the Charter. The Supreme Court of Canada gave effect to it. So you win, right? Years of work, thousands of hours, and the court gives Parliament 1 year to decide what to do. So on December 6, 2014, Bill C-36 came into force. The new law, which on its face claims to be designed to help women exit the sex trade, in fact, in our view, serves only one purpose, and that purpose is the promotion of the government's moral agenda. The law that we now have in place reproduces many, if not almost all, of the same harms as the ones that were found unconstitutional by the Supreme Court. Sex trade workers will again be forced to ply their trade in a hurried fashion, won't be able to take basic safety precautions, and will do it in the dark. Welcome to the Vancouver East Side. And Mr. Picton. But even worse, the government has now created a prohibition against any advertising, making it impossible for indoor sex workers to find clients, or clients to find them. The new laws are aimed at ending the sex trade, which most of you will know is the world's oldest profession. The practicality of that suggestion suggests this will never happen. Do more sex workers have to die before the government acknowledges that moralizing laws many times don't work? The record in Bedford was designed to put new evidence before the court. It was designed to show how times had changed since the prostitution reference in 1990. But to start all over again, it'll take 20 years of research to develop the empirical understanding of the effect of the laws. I have no doubt that 20 years from now, we'll be again asking ourselves, okay, why are so many sex workers dying? But if the government of Canada had taken the Supreme Court of Canada's decision seriously, it would have put the safety and security of sex workers first and learned from the mistakes of the past 20 years. This case raises disheartening caution about the state's response to an important decision of the Supreme Court of Canada. By necessary implication, it is a caution about how public interest litigation, even if successful, can ultimately fail to provide any of the legal remedies sought. Now, I'm going to turn to another issue around public interest litigation, and I'm going to use the example of Ashley Smith. And I'm so glad that Professor Kim Pate is here, because we could have another 10-hour discussion and carve out how we might do such litigation. My view is a simple view. Hers isn't. But I don't believe we should abandon test case litigation. But I sound a note of caution about putting the resources into a place where we can't be confident that we will get a remedy that is meaningful for a class of people. So I find the Government of Canada's attitude utterly incomprehensible when we look at the events surrounding Ashley Smith. And most of you will know, but for those who don't, I'll just do a high-level summary. Ashley was first incarcerated as a very young woman for throwing an apple at a postal worker. Ashley then went on to spend days, months, and years as a mentally ill inmate in our correctional system, where she was transferred 17 times and where she was placed in solitary confinement over and over and over again for more than 1,000 days. She attempted suicide several times. Guards were told that they ought not to enter her cell if they could see anything unless she had stopped breathing. So what did they do? They stood and watched her die. The coroner's inquest in Ontario ruled that her death in these circumstances was a homicide. And the inquest made very important recommendations, and I only summarize a few. That indefinite solitary confinement should be abandoned. That's number one. Solitary confinement, and of course the language of corrections is never solitary, it's segregation. Solitary confinement should not exceed 15 days. And a restriction must be placed on how many continuous periods can be imposed on an inmate. Now, the Ashley Smith inquest was a very important process in the province of Ontario. Many people were involved. Kim's organization was very involved. So these recommendations were the collective wisdom of a lot of work and careful thought. So what does the Correctional Service of Canada do? It publicly rejected the recommendations very, very recently. And its inaction has been condemned by E. Fry, John Howard, Howard Sapir, and even Louise Arbour, a retired Supreme Court of Canada Justice with a long and impressive record as the senior prosecutor for the International Criminal Court and the former UN High Commissioner for Human Rights. I loved the interview with Ms. Arbour with the Globe and Mail. She said Canada's addiction to the use of solitary confinement should not be tolerated. She went on to point out that this practice might well be included in the government's list of barbaric cultural practices. Now, we need to remember when we think about this that 1 in 6 prisoners held by the Correctional Service of Canada spend more than 100 days at a time in solitary confinement. Only 2% of the population is there as a result of disciplinary processes. That 2% gets an independent review. There is a limit. It's 30 days. In the meantime, solitary confinement for others can be limitless and without any meaningful review. If it includes placing the mentally ill in solitary confinement, it is inconceivable to me that this is not utterly destructive of their well-being and mental health. So what is the solution? 2 beds have been created. 2 beds to be dedicated to mentally ill prisoners. It doesn't even begin to meet the problem. Now, over the Christmas break and kind of thinking about what I might want to say, I began to, in my own mind, create a test case. And I thought, why don't we launch an application? Why don't we argue that CSC's use of solitary confinement or segregation, without limit, without review, for the mentally ill, constitute cruel and unusual punishment under our charter? In fact, I think there's an arguable case that it constitutes torture under the convention. So I thought to myself, okay, so if we were going to do this, where would I start? And this would be the kind of decision-making tree that all of you who are involved in test case litigation would start. You ask yourself, who are the organizations that have the greatest interest in this issue? Well, that immediately leaves me to EFRI and to John Howard as the 2 principal organizations. And then I thought, yes, but if we wanted to include some First Nations persons in this, we'd need Aboriginal Legal Services. We need to contact Jonathan Rudin or someone else who has access in the community. We need to find maybe 6 or 8 people who would be prepared to stand. It has to be enough so you can monitor that they're not punished by CSC. But 6 or 8 people who would come forward as applicants to seek to have this practice declared a violation of Section 12. Then you tell, if you were doing it within a law school community, you'd say, okay, let's take 4 students, go out and find the research. There is a wealth of research on the damage to human beings caused by this kind of conduct inside corrections. There is a wealth of research about the harm and the problems that are attendant upon the use of solitary. Then you'd say, okay, if you have that research, there are professors, academics, psychiatrists, people out there who have worked on this issue. Get a list of the top 10. And in public interest litigation, you often find that people who have devoted years of their life to the study of some phenomenon, when they get the phone call and say, would you be prepared to act in this litigation? I'll give you a copy of the application. This is our objective. Would you be prepared to be an expert? My experience now is that most people say yes. And then we say, well, we have to discuss fees because we don't have any money. And they would say, fine, I'll do it for free. And that is, by and large, on important issues like this, the response that one would get. So you take your research, and then you look at your applicants, and you have to make sure that the applicant's personal circumstance actually relate to the research so that you have a real connection between the two. In addition to those experts that you've found, you'd want to add the international community. So the first thing I would do is pick up the phone and phone Louise Arbour and say, in light of what you've said, Louise, would you kindly consider being an expert in this case and talk about the UN's position? And I must admit, I love the thought of someone from the Department of Justice trying to cross-examine her. Then we would look around for a possible funder. I believe that there are funds available for some important test cases. I think, I'm going to shorten this because I want to have a chat with people as well. I actually think you can fundraise within the communities of affected persons. And while I was preparing my remarks, my young associates, who are infinitely more techno-savvy than I am, said, Marlys, why don't you tell people about crowdfunding? I said, what's crowdfunding? They shook their head as usual and said, well, this is happening in the United States now. you can raise money. People can put a nickel in. If you get enough nickels, you can get thousands and thousands of dollars, depending on how you cast and frame the issue. People will put $1 in. And so I want to leave this with you, if nothing else. It's called www.kickstarter.ca. And apparently, there are 2 huge pieces of litigation that have gone forward in the United States with that kind of fundraising. Now, leaving aside the internet, I come from Ontario, and I don't know what the position is in Saskatchewan, and I apologize for not being more familiar with it. We've recently set up a committee that we call GATSI, and I sit on that committee. And the purpose of the committee is solely to provide legal aid funds to test cases. So our budget has grown significantly in the last year. And what we receive are applications for test case funding. Those test cases range from, an application by an intervener who wants to participate, and they don't have the funds to even get organized to participate in litigation at the appellate level. It relates to primary level initiatives. So, for example, one of the things that we just recently considered was this whole issue of withdrawing health care from refugees. And, everybody in legal aid blinked when counsel was saying, well, at this level I probably need 100 and blah, blah. And I'm sitting there saying, that's cheap. It's a very important issue. So we funded it. So legal aid in Saskatchewan needs to be pushed to create such a committee, and there is a model for it, and it's doing very good work, and we're very proud of its relationship to test case initiatives. So I believe test cases will continue to be a very important challenge for you as advocates, for those seeking social justice. We need to remember there are some cautions around them, and I've talked about one, which is the mess of Bedford. Who would have ever thought that after all that work, we'd end up with the worst case scenario possible. But one of the issues I think that I want to just touch on is when you become involved or think about test cases, I was doing, and then I ran into Kim, and then we were kind of talking. Test cases must have litigants that are not the lawyers. There must be real human beings attached to test cases. They must understand and support and be able to participate in the litigation. And I wanted to just say a caution, because I've seen this happen several times where test cases become lawyer-driven enterprise. There's a very famous story about the NAACP. After it won the decision in Brown versus the Board of Education, there were issues about where else they then could litigate and where should they focus their resources. And the black community was fundamentally split. The NAACP wanted to focus only on racial integration. Let's bus these kids to white schools. There was a huge element of the black community that said, forget it, we don't want to bus our kids. We want money put into improving education in our schools that are close to home. So one of the really challenging issues for anyone who's a test case litigator is to ask the question, what is your relationship to the whole community the test case will affect? So, for example, if we set out to take out solitary confinement, I am sure we would be confronted with the fact that there are some people in solitary who would say, leave me alone. I want to be left alone. I don't want to go into general population. Now, I only say that to say this last comment. There are complex ethical and moral issues that go along with the tremendous responsibility of conducting this kind of litigation. And I want to stop there, but only say this to you. There is much work for you to do. Test case litigation will be a powerful tool in your hands. And I'm sure I'm joined by many in my generation as we hand the torch to you to say, good luck. This is an important endeavor. Thank you.
We have a few moments for questions
Sure.
and observations. I welcome
Be
you
nice now.
to jump in.
And we know people have class at 1, so those who need to leave, we'll see you later.
Marlys, I'm just wondering, not being all that familiar with test case litigation myself, how much coordination, how much cooperation do you tend to see between the various parties appearing at the court? I mean, what I'm thinking specifically is the matter that's currently under consideration for the Saskatchewan Federation of Labor case out of Saskatchewan. There was really almost unprecedented, I would say, level of coordination with various unions, interveners, and parties who were appearing in terms of what arguments were going to be made, what general approach is going to be. In the test case litigation that you undertake, do you find that there is that sort of coordination among various parties, or what's your
I think it depends a little bit on the nature of the test case. Certainly when, some test cases that I'm involved in come out of the criminal justice system, and they solely reflect the circumstances of an individual accused and counsel's decision to raise major constitutional questions. This case of Swain is an example of that. But you're one-on-one with the administration of justice. I've certainly also participated, and not infrequently, in cases where there is much more coordination. So, for example, in the last 3 or 4 cases I've done, there has been a high level of coordination. You recruit interveners. I mean, if a case represents something that, from your perspective, you think Amnesty should be concerned with, or BCCLA, or the Canadian Civil Liberties Association, you get on the phone and say, where are you? So I have found, and then you organize, and I don't mean you, but the group organizes itself so that their individual lenses that they want to bring to an issue can be put forward and convince the court that they're separate lenses, and the court would benefit by the richness of those. So my experience is there's a lot of coordination. And I think we all now realize if you want to get in as an intervener in the Supreme Court of Canada, you have to say, for example, we've talked to the parties. We will and have met with the other interveners. We will ensure that our arguments do not duplicate. And this will be our position here, and you need to hear it because of X. And so I think more and more that happens. And certainly more and more interveners are present in even the Court of Appeal, not just the Supreme Court of Canada. So if you're going to do it, even if that's unusual, you have to make a commitment to working collaboratively. Any other thoughts?
Thanks, Marlys. I wanted to ask you about 2 elements that you're obviously very familiar with both of these, I think. And I think the first sense of the state of proceedings post the court's judgment within Swain, and that's continued, of course, in the district matter. But I point out that, at the moment in Saskatchewan, we're still defending Section 213 cases that are being prosecuted, I guess, justified by the state of proceedings. And secondly, but on the other hand, it seems like the Supreme Court has really changed its attitude on exclusion of evidence. In
Yes.
many cases,
Yep.
the test case accused was winning and getting the evidence excluded, and I'm thinking of Bridges or the right to counsel cases, for example. We started a case here, the Spencer case, about privacy of cell phones, and Spencer was eventually right at the Supreme Court of Canada that they needed a warrant, and yet they didn't exclude the evidence. And frankly, being counsel on such a case is very impressive. We spent 7 to 10
10 years.
on that issue to win, but the accused lost, and it's really hard to advise that accused. So those 2 things in common, it seems to me, really discourage this kind of litigation.
Yes and yes. The Declaration of somebody needs to write about the Declaration of Invalidity from an academic perspective, because essentially what happens is the Supreme Court strikes out the laws and says, okay, we'll give the government 6 months, a year, they can figure out what they want to do, and they have to fix it, because the laws will, at the end of that period of time, will cease to be operative. It causes enormous confusion in the system. Nobody can figure out, well, okay, there's unconstitutional law, there's a Declaration of Invalidity, and we've got, 100 charges before the court. What are we supposed to do? Do Crown Counsel stand up and say, well, I'm proceeding? Do you say, well, we give up? Or do we say we want a year's adjournment? Or, I don't know what the answer is. And it caused chaos in Ontario. And I'm sure it did here as well. I don't think the court knows just how much chaos it causes. And it almost seems to me that what we need now is someone to stand up in the Supreme Court and say, if you're going to do that, you have to address the following secondary issues. So people know what to do with this Declaration of Invalidity. Does that mean all prosecutions should be stayed? Because in Ontario it was a mess. Now we have the new law, and because there's disagreement about Bill C-36 and whether it in fact is good, Kathleen Wynne in Ontario has a group of people who've asked her to consider referring it to the Court of Appeal. And we'll see where that goes. But police are not enforcing it. And I don't know what's happening here, but they are certainly not enforcing it on the street level at this time. Now let's talk about 24-2. Yes, the recalibration of the principles means I think you rarely win. I think it's very difficult. So I guess we have to go back and knock on the door. Perhaps wait for a slightly differently constituted court. I don't know. But I agree with you 100%. No one would have ever thought that case would have the evidence go in.
One last comment. One thing that I found amazing in that I was involved with the Over Cotter case to some extent through my friend Dennis Edwardh at Edmonton.
Yes.
One of the things we did in terms of fundraising for Dennis for over Vietnam was set up a website, and we used PayPal as the website payment method. And for my shop, PayPal decided that since Cotter was a terrorist, that they would not allow us to use their services.
Unbelievable.
Still astounding that
Unbelievable. Well, I did, when I was thinking about what my associates had suggested, this crazy thing from Kickstarter, I said, well, if I were going to do, let's say, a challenge to the marijuana laws, and it was quite clear that the only beneficiaries would be users or traffickers, would I have to be concerned that using this vehicle implicated me somehow with proceeds of crime stuff? So I picked up the phone and phoned an old friend of mine who's prosecuted for years at the Department of Justice and said, would I be in trouble? To which he answered, no. So I'm not surprised at PayPal. I don't know what would happen if you'd gone another route. That's actually shocking, isn't it? Unbelievable. Yeah.
Thanks so much for your comments. One of the main barriers of identifying for us is the state's response to successful US case and seeing the state pushing back against the recommendations of court. So increasing dialogue around like the symbiosis of leadership and culture shifting and creating the ideology of the critical will to make steps in forward to changing the rules. And I'm just wondering what strategies you've seen or employed that have been successful at creating a critical will for the state to adopt and accept the legal remedies that the court is.
Well, it's a very, very interesting question, and let me tell, that's why I talked about the paradigm shift in the administration of criminal justice. Because once those inquiries existed, once jurists reflected on the administration of criminal justice and said, oh my God, it's a mess, how did we end up here, that opened within the community of those who were, committed to the criminal justice system, opened the dialogue. And there was a commitment about change and measuring prospective change against this model of avoiding convicting the innocent. And everything from Steve Gouge, and it's a huge area. So that's what changed it in my world, all right? And now I see the other happening largely as a result of a political message. But let me take Ashley Smith, all right, for a moment. Her circumstance got so widely publicized. I have never met anyone who was not horrified. Because we watched on TV. Ordinary Canadians could sit in their living room and we saw pictures of her die. Okay, so such an event should be able to harness a community of persons who are willing to spend time and energy. It may not, it will have to be something, we can harness the rage. From judges I know, to lawyers I know, to friends who have nothing to do with the law, watching what happened with Ashley Smith was a disgrace, and they do not want to tolerate it. So that's an event that occurred. And we can benefit from the discussion and the condemnation and invite a resolution to that. So then when you get to other more complex things, I think the discussion is hard to generate outside of a court if you're just a lawyer. There has to be something bigger than a lawyer. I think people are nervous about the world as it exists. The comment about Omar Khadr is terrifying. But I appeared actually for the Criminal Lawyers Association in Khadr in the Supreme Court of Canada, but I represented a man who was just removed to France in an extradition, and his name was Dr. Hassan Diab. He was a professor from Carleton. He was arrested for the bombing of the synagogue on the Rue Copernic in 1980. I believe he's innocent. And one of the problems with the French system, criminal justice system, is when charges are terrorism charges, they've created quasi-military tribunals. So the evidence that goes before them includes intelligence. So even the judge hearing the case never knows where the evidence came from. So if you're reading along, it says, oh, a reliable foreign intelligence agency told us it was him. Yeah, well, who? How? From what basis? They never heard. Even the court doesn't know. So I was gobsmacked this year when the Supreme Court of Canada declined leave in a case like that. Now, when you start walking those kind of lines in a case, while I had interveners working with me, Amnesty was there, the BCCLA was there, other folks were there, but it's hard to get broad-based community support. I mean, the Canadian Jewish Congress was against this. The COUT was helping us, which is the Association for University Professors, but you're walking a fine line trying to gather support. So I don't have any magic answers.
I'm going to encourage anyone else who has any questions to come up after and chat with Marlys. I want to take the opportunity, Marlys, to thank you for encouraging us to think critically about the human experience and its relationship to litigation, and vice versa, and our role as lawyers within that picture. So, thank you very much. A little acknowledgement of your role as visiting scholar. Thank you so much. Thanks for joining us. Marlys is around the college for the next 2 days, so seek out the opportunity to come and talk to her if this hasn't satiated your interest. So thanks.